Washington, the status of abortion access in Texas was once again thrown into uncertainty Wednesday night after a federal judge issued an order halting enforcement of what he described as the state's flagrantly unconstitutional 6-week abortion ban, the immediate effect of U.S. District Judge Robert Pitman's 113-page ruling, and whether it will mean that providers can, or will, resume performing abortions, is uncertain. Just over an hour after Pitman issued his order, Texas filed notice that it would petition the U.S. Court of Appeals for the Fifth Circuit to intervene. The state is expected to ask the appeals court to put Pitman's order on hold as quickly as possible, which would leave the law, SB 8, in place. Pitman's ruling came less than a week after he heard arguments on the Justice Department's request for an injunction blocking the law. He refused to grant Texas's request to pause his decision to allow state officials time to appeal, writing that Texas had forfeited the right to any such accommodation by pursuing an unprecedented and aggressive scheme to deprive its citizens of a significant and well-established constitutional right.
From the moment SB 8 went into effect, women have been unlawfully prevented from exercising control over their lives in ways that are protected by the Constitution, Pitman wrote. That other courts may find a way to avoid this conclusion is theirs to decide. This court will not sanction one more day of this offensive deprivation of such an important right. Abortion providers released statements praising Pitman's ruling, but suggesting they were not sure yet if they could begin scheduling abortions that SB 8 had made illegal. The law includes a section that says doctors who perform abortions or other people who assist a pregnant person based on a court decision that is reversed later on cannot rely on that original order as a defense if they're sued. Planned Parenthood affiliates in Texas released a joint statement saying, while the Department of Justice's swift action and the court's order seek to restore Texans' options to access abortion in their own state, we understand Texas will immediately appeal. Our patients and providers need the courts to allow care to resume. SB 8 has been in effect since September 1st. It bans nearly all abortions after fetal cardiac activity can be detected, which typically occurs around the 6th week of pregnancy. Pitman's order bars any state actor from taking steps that would permit enforcement of the law, which deputizes private citizens to sue doctors suspected of performing abortions or other individuals suspected of helping a pregnant person obtain the procedure. The judge made clear that his order prohibits any state court judge or clerk from accepting, processing, or taking any other action on the civil lawsuits that private individuals could bring under SB 8. He wrote that the court would have the power to issue a direct injunction that bars private individuals from bringing these types of suits, since they would be acting on behalf of the state, but he would not do so at this stage. He noted that his order blocking state courts from accepting such a case would restrict their ability to act. A person's right under the Constitution to choose to obtain an abortion prior to fetal viability is well established. With full knowledge that depriving its citizens of this right by direct state action would be flagrantly unconstitutional, the state contrived an unprecedented and transparent statutory scheme, Pitman wrote. Pitman ordered Texas to notify all state judges and state court employees affected by his decision and to publish his ruling on all public state court websites with a visible, easy-to-understand instruction to the public that SB 8 lawsuits will not be accepted. Addressing Texas's argument that siding with the Justice Department would open the floodgates to federal challenges to state laws, Pitman wrote that this case represented an exceptional situation where the constitutional rights of individuals were being violated and Texas had designed SB 8 to bar them from taking the state to court to protect those rights on their own. Pitman rejected Texas's contention that a court couldn't issue an injunction against the state since the law was enforced via lawsuits filed by private individuals. He criticized the state for trying to use the unusual enforcement structure as both a sword to carry out an early-term abortion ban that courts would almost certainly strike down if the state tried to enforce it on its own, and a shield against legal challenges. The judge wrote that his order would send a message to other states that they could not attempt something similar to what Texas had tried to do, whether it was intended to serve a conservative or liberal political agenda. He alluded to commentary by pundits about whether SB 8 could serve as a model for Democrat-led states to find a way to restrict gun rights. The American legal system cannot abide a situation where constitutional rights are only as good as the states allow, the judge wrote. SB 8 took effect at midnight on September 1 after abortion providers failed to convince the U.S. Supreme Court and a federal appeals court to stop that from happening while they pursued a constitutional challenge. Healthcare providers across the state immediately announced that they would comply with the law and stop performing abortions in cases where fetal cardiac activity could be detected, usually at the 6th week of pregnancy. Providers have said 85 to 90% of abortions in the state take place after week 6. Pregnancy terms are counted from the first day of a person's most recent period, so 6 weeks is typically 2 weeks after a missed period, which is when many people first realize they're pregnant. Early-term state abortion bans are often referred to as heartbeat loss, but that term is misleading, since a fetus's heart valves haven't formed at that point. An ultrasound at that stage is detecting electrical activity. Pitman wrote in a footnote that the term heartbeat was medically inaccurate. With the abortion provider's case held up in the Fifth Circuit, the Justice Department filed its own constitutional challenge to the law on September 9. Unlike other early-term state abortion bans swiftly struck down by federal courts, the Texas law is unique in that it delegates enforcement to private citizens. Instead of authorizing a prosecutor to press charges or interfering with a clinic's ability to get a license and operate, the law empowers individuals to file a civil lawsuit against a doctor they suspect of performing an abortion that's now illegal in the state, or anyone who aids or abets that abortion, a category so broad that it could apply to a person or group that helped pay for the procedure, provided transportation to a clinic, or accompanied a patient.
Thank you for watching. Please subscribe.